yajaa.
All right, thank you for staying with Kenya's Choice 2022 right here on Citizen TV. Let's start that conversation. We'd like to hear your views as well at Trevor Mbija at Citizen TV Kenya. This conversation is about the Supreme Battle, the Battle Royale that we're talking about. Professor Ketch Migai is here, Advocate of the High Court. Kennedy Chesa, Advocate of the High Court, is also joining us from Kakamega. Prof, thank you for making time for us.
Thank you, Trevor.
There's a total of about 8 petitions plus a cross petition. How is this likely to play out in the corridors of justice?
They are likely to be consolidated. The first order of the court will be to consolidate the petitions, and you'll have a lead petition. Most likely, the Raila Odinga petition, I suppose, will be the lead petition.
Okay. But
yes,
when
they'll be heard as one.
But when there's a cross petition, like the one filed by Chama Chakazi party leader Moses Kuria, petitioning the Supreme Court, seeking to block that very petition against President-elect William Ruto's victory. In his petition, the current Gatundu South member of parliament, of course, he ran for governor and he lost. So as it stands, he's still the MP until the new one is sworn in. But in his petition, he wants the petition by Raila Odinga thrown out because he's citing acts of violence at the Bomas of Kenya.
Which have to be proved.
Okay.
Yes, I suppose that will be a matter for the court to decide. I don't think it will take any priority.
So that is most likely going to be thrown out as well?
No, I don't think it will be thrown out. I don't think it will take a priority.
Okay.
That the court will hear it as a matter of priority.
Okay.
I don't think so.
Chesa, what are your thoughts on this? What are the likely outcomes?
The likely outcome is that after these 9 petitions have been filed, they will be consolidated into one, and one of the petitions will be the lead petition. And as Professor Migai Ketch says, the Raila Odinga petition is likely to be the lead petition. As to the cross petition, I am not certain that that will, strictly speaking, qualify for a cross petition because Moses Kuria has not been taken to court by the Azimio. The respondents are well spelled out. And the cross petition is likely to be heard, but at the time convenient to the court. And at the very worst, if it is raising salient issues to be addressed in this petition, then it will be part of the consolidation. But it will not take priority over the rest. It is not challenging the election of the president. It's only citing acts of violence that are anticipated by dint of Section 80 of the Elections Act.
All right. And Prof, let me bring you back to another conversation here. So this whole petition, and like you mentioned, that it's a very dicey line between sub judice and the merits of the case. But let me take you back to 2017. The Raila Odinga case versus IEBC in 2017. One of the issues that was talked about, that the election can only be nullified if there's substantial violation of the law. But there was no description of what substantial is. How is that likely going to affect this petition?
It is very much likely to be at play. So let me start by explaining the 3 things that an election court can do under the Elections Act. If you look at sections 80, 82, and 83, what you're talking about is in section 83. So an election court has 3 options. It can recount the ballots cast. You can imagine that would be a monumental task in a presidential election. Imagine recounting all the ballots cast in all of Kenya. Number 2, and recall that the Supreme Court only has 14 days to determine a presidential election petition. Number 2, it can order for a scrutiny of the votes. And it could be a partial scrutiny or a scrutiny of all of the votes. And essentially, you're talking about an audit of the votes. And finally, it can nullify an election. It can nullify an election in 2 circumstances. It can nullify an election where it is proved that there were substantial violations of the Constitution and the Elections Act by in and of themselves. You don't need to show anything else if you go by the decision of the Supreme Court in 2017. But that again has issues, and I'm going to talk about that. Yeah. Alternatively, you can prove that there were illegalities and or irregularities that affected the result. Again, there's a substantial test. So if there are minor errors, then then that may not matter.
Okay.
But in this instance, in the second instance, there must be a demonstration that these irregularities affected the outcome of the election. And irregularities, if you recall, in 2017, they were talking about the problems that you had with the Forms 34A, for example, that they didn't have security marks, they were not signed, etc.
Yeah.
That kind of thing. Illegalities, you're talking about the misuse of state resources, for example, that certain public officers were campaigning for a particular candidate, that kind of thing. As you can imagine, that is going to be very difficult to prove. And if you recall in the 2017 petition, whereas the Raila Odinga team presented some evidence, the court was not persuaded that they affected the outcome. But now coming to the substantial violation test, essentially it is saying that we did not have an election, that what we had was a sham, a travesty. And there are different ways of looking at what amounts to a substantial violation. Again, the different cases that have tried to explain substantial violation. If you look at it from the perspective of the Supreme Court, what it said is that, yes, voting and counting was okay in 2017. What we had a problem with was the tallying process and the transmission of the results to the National Center. That is where the problem was. Now, if you look at it from a substantial violation perspective, you have to ask yourself, did that in itself constitute a substantial violation? The dissenting judges in 2017, Justices Njoki Ndung'u and Ojwang, disagreed. They basically claimed that their colleagues were throwing the baby with the bathwater, because we're saying we have votes, why don't we count them? So again here, we were going to ask, did we or did we not have an election? And the test would be what the reasonable Kenyan thinks. Did we or did we not have an election? Can we say that the election of 2022 was a sham? If we look at it from a big picture perspective, obviously, as you can imagine, there'll always be issues in an election. But, and this is what the Azimio petition is trying to test, if we look at it from a big picture perspective, will the court be persuaded that we did not have an election? Because if the court is not persuaded that we did not have an election, then it cannot nullify it. Okay. Then the other remedies are going to be more suitable.
So chances of nullification here are minimal?
They're going to be, in my estimation, it's going to be very minimal. Okay. Unless, of course, we are persuaded by the Azimio's team in terms of how they present their evidence. Yeah. We've not looked at the affidavits. A case really turns, in these petitions, the case turns on the evidence that is presented, and the evidence is presented in the form of affidavits. Yeah. So we need to look at, and in the petition they're alluding to various affidavits. We need to look at them, and of course the other side is going to respond. Yeah. But essentially that is the test that they have to prove. Will they be able to persuade the reasonable Kenyan that we did not have an election? Okay. It's a difficult test in my view. Okay. Yes.
Chesa, what are your thoughts on this? Because the other issue is the evidentiary threshold. We saw earlier on today a whole lorry full of evidence, and we know the court has 14 days. Is it practical that they'll go through all that?
Some of the things we are calling to be evidence on that lorry was actually carrying the attachments. You know, if I'm quoting the Elections Act, Section 80, 81, and 82, I may attach the entire Election Act. I may attach the entire Constitution. So the judges may not be called upon to see every document that was attached to that petition. The petition itself, the Raila Odinga petition, is about 72 pages. The rest are attachments. I want to believe that the court has been invited to audit the election that took place on the 9th of August 2022. And the court is being asked by the petitioners to audit this election and see whether it complied with the Maraga directions as given by the majority judges in the Raila Odinga petition of 2017. Maraga and the majority judges stated that election is a process, is not a one-day event. And keenly looking at what Azimio is presenting as their petition, they are relying on the statements of the majority judges saying that Maraga asked IEBC to conduct further elections in compliance with the Constitution and the electoral laws and ensure that the process is as clean as the numbers that are then brought therein. You have seen the story of the Venezuelans coming back. You've seen the conduct of the commissioners, the conduct of the staff of the commission being put to question. As it is, the Kenya Kwanza team has not put in any response. And the question I will ask myself is, if Kenya Kwanza elects not to respond to this petition, will it succeed? Obviously, it will succeed. So until Kenya Kwanza makes their response and the Azimio comes in with the affidavit and we weigh the kind of evidence that each side has, we cannot actually tell that one side will succeed, the other side will not succeed. Remember, in the election petitions, the court has already pronounced itself on the matter and the issue of the evidentiary burden. The evidentiary burden lies with the petitioners, and that is in line with the law of evidence, that he who alleges must prove. But this evidentiary burden keeps shifting. If one side alleges a matter to have occurred, then that particular side has the burden of proving it. And the burden required in an election petition is not as high as that burden required in a criminal matter, which is beyond reasonable doubt. So Azimio is not being called upon to prove its petition beyond reasonable doubt. It is asked to prove it slightly above preponderance of evidence or the balance of probabilities. So in my opinion, and looking at the pleadings and the petition as has been drafted, it raises very salient issues, especially if you compare with what the majority judges designed an election to be. And remember, the Maraga court said it will not hesitate to nullify another election if the similar offenses, the similar omissions that were made by Chebukati in 2017 were to be repeated. So in my opinion, it will be an audit as to whether the IEBC of 2022 complied with the directions of the majority judgment in Raila Odinga 2017.
Yeah, and Prof, I read your article on. In your own estimation, did they comply? Did the IBC of 2022 comply with the judgment of 2017?
There is, we can only work with what we've seen so far.
Yeah.
I mean, perhaps the things that happened behind the scenes that the public is not aware of and that will be revealed in the fullness of time in this petition. But there was an appearance of compliance with a lot of things. And perhaps the best demonstration of that was the near real-time transmission of all the Forms 34A to the National Tallying Center. So in many cases, as I see it, the petition will turn a lot on, did we get the results from the polling stations? Did we get the correct results? Were they signed? Are there discrepancies? If you look at what Azimio is alleging, for example, that there is a variance of some 140, the magic number,
Yeah.
140,028 votes, between the total number of votes recorded in Form 34C and the total number of votes identified using the KIMS kit. But I think that is a matter of evidence that is easy to demonstrate. If the court does a scrutiny, the court should be able to demonstrate that, look, we voted okay as citizens. We counted okay.
Yeah.
The people that were at the polling stations entered the marks okay. They were signed. I took a cursory look at some of those forms, and typically what I was seeing is the agents and the IEBC officials agreeing. So if that is the case, then it's a problem with the next steps. Mm-hmm. But if you have the primary records, then that should not be easy to resolve. That should not be difficult to resolve, in my estimation. So it will turn a lot on whether what happened
Yeah.
at the polling station was credible. Azimio is alleging that in some 41 polling stations, that did not happen. That, for example, there were Forms 34A that were incomplete and inaccurate, and then you ask, are they just talking about some or all of those forms? Eh?
Yeah.
They will tell us when they present the evidence. And then they're saying that there were Forms 34A that were issued to agents at the polling stations and electronically transmitted, and that those vary from those that were displayed at the portal of the IEBC. So they're saying they've sampled some forms. They're saying that Raila Odinga's votes were reduced and William Ruto's increased in some cases, and that Raila Odinga's votes were in some cases just reduced and without any alteration of Ruto's votes on the other hand. But so these are things that will be proved.
Yeah.
And of course, Kenya Kwanza will have their side of the story to tell, but that is what they are alleging. So in many cases, I think it will turn on what transpired at the polling station. And I find it interesting that Azimio has casted their prayers in the alternative. Mm-hmm. In the alternative meaning, well, they're saying, look, first of all, we want you to nullify the declaration of the results, tally and vary the count and declare Raila Odinga and Martha as the duly elected ones, as the duly elected president and deputy president. Yeah. But in the alternative, we want you to nullify the election. So it's curious, I mean, and the ordering. Mm. Is it that they are also not persuaded that this was a sham election? I'm inclined to believe that. Okay. Because their petition seems to be pointing in the direction of let us audit this process, and if there was a winner, let the court declare that winner. Mm. And if that is the case, then the court should also punish the people that are responsible. So in some ways, they're also going after Chebukati's throat. Yeah. They're saying, if we find this person guilty of all these election offenses, he must be held accountable for it. Mm. Yes.
It's just, are you also seeing a disconnect between those prayers like Prof is raising? Because it is true that if you want an election nullified, then how then would you ask one of the prayers to then declare you as the duly elected leader?
However, as an advocate of the High Court, when you approach a court for the resolution of any dispute, legal dispute before that court, you make all prayers available and as are legally conceivable. You do not intend then to have all those prayers granted, but you do not want to run the risk of being asked by the court, why did you not make such a prayer, or why do you omit to make such a particular prayer? So that don't just rely on the goodwill and the discretion of the court to give any other prayer as it deems fit. And therefore, Azimio is justified to place as many prayers as are legally conceivable, so that the court, having assessed the evidence that will be placed on record, can give them the best prayer in their own terms of presentation. When you are asking the election court to declare Raila Odinga the winner, for example, after tabulation of the results and indicating that Raila is winning, that is what Section 80 of the Election Act provides. When you are asking the court to nullify the election if it was a sham, that is what the Constitution provides and bestows upon the Supreme Court to do if irregularities and illegalities have been committed in an election. Therefore, this points to the fact that after Kenya Kwanza has presented its evidence, of course there will be oral highlighting of submissions, then the court will retire and evaluate the evidence that has been presented by both parties and look at the prayers that can be supported by the evidence as presented. So the idea of advocates or litigants going for as many prayers as possible, it is not new with the Azimio case. This is what by practice and as advocates we do. We go for every prayer that is available. It is up to the court to sift through the prayers and award the ones that have been supported by the evidence that has been placed on record.
Yeah, and Prof, just for my understanding, because I'm not a legal expert myself, I mean, the whole lorry of evidence, will the judges have time to go through all that?
The essence
the judges
of it.
Will have to.
I'll come to you, Chesa. Let's Prof.
The essence of it, it is sieving the evidence in terms of the issues and the supporting documentation. And primarily, it will be in the affidavits, which are not likely to be very voluminous. I think a lot of them are reference documents. As you can imagine, 14 days is a very short time. But as you also know, the court has very good support in terms of research assistance. So I believe they're up to the task, and that should not be a challenge.
And they will go through the entire lorry?
The entire lot, in terms of, I think a lot of it is supporting information that you will refer to if and when you need clarification. For example, in an affidavit, if somebody is alleging that we are not able to verify the turnouts contained in the kits, in the KIMS kits, for example, then you can go to it.
Okay.
So I think a lot of them are reference documents.
Okay. So there's another issue that you raised earlier on, Prof, and that was, I think, there are a total of 24 prayers. I'll just pick two of them, 9 and 10.
Yes.
9 is the one you're talking about, that an order be hereby made consequent upon the nullification of the declaration of the results by the second respondent, directing that the first respondent to tally and verify the count and declare the first and second petitioners as duly elected as president-elect and deputy president-elect.
Yes.
But then the 10th one is another issue. A declaration be and is hereby made in the alternative to 9 above that the first respondent, as presently constituted and as presently functioning, is incapable of presiding over and rendering a proper, credible, verifiable, and valid presidential election, and that the court do make appropriate orders to uphold the Constitution and defend the sovereign will and the power of the people of Kenya. So, should that particular one be granted, then how will this rerun even be possible?
It would
because
be
it is
possible
60 days from today.
It would mean we have a constitutional crisis.
Okay.
If we declare that the
IEBC as presently constituted cannot carry out a verifiable election,
it means we'd have to find a way of establishing a new IEBC. Who's going to appoint them? At the moment, we have a president whose powers are limited. How much time will it take to do all of that? Will the parties have confidence in the newly constituted IEBC?
Will they have enough time to even acquaint themselves with what goes on at the IEBC?
Exactly. How much time typically would a newly constituted IEBC need to be able to preside over an election? So that would be a very difficult scenario for the court to contemplate, I would imagine.
All right. Echesa, so what...
Essentially, we'll be talking about a constitutional crisis.
Yeah.
Yes.
Echesa, so what then will the court be considering when there are certain prayers, like Prof is saying, that will lead to a constitutional crisis?
I think the court will make orders in public interest. They may not make orders that will stall this country, that will plunge us into a constitutional crisis. And considering that, then that prayer may be inconceivable. It may be very difficult for the court to grant such a prayer. But if you get progressive judges, if you get a progressive court that is hell-bent on correcting the electoral messes that we've experienced as a country over decades, then they will not hesitate to make such a prayer. Remember, one of the celebrated judges in this country, while making a very serious decision on the eve of election, recalling the county and constituency returning officers, said that justice must be done even if the skies will fall. So we are going to a situation where the Supreme Court may be allowing IEBC to bungle election after election after election, and perhaps that's where Azimio has come up with that prayer, that if the IEBC bungles an election, it is not given another opportunity to bungle an election. And we also ask ourselves, like Wanjiku would ask, or like Makoha would ask, what is the purpose of Kenyans voting every time, and the commission bungles an election? We go to the courts courts nullify the election and the same commission is allowed to again bungle an election. It would be a very serious decision to make, but if that is what it takes to correct the electoral mess in this country, I think we'll rather go into a crisis once and for all and solve the problem and have credible elections going forward. We cannot be kept in a cycle of a commission bungling election and being allowed to bungle an election just in the guise that if it were told not to carry out an election, we are going into a constitutional crisis.
But I mean, if I may,
yes, Prof.
I think that is one way of looking at it.
Okay.
The counter argument is that could be that the election was not bungled. Certainly there were irregularities. I can imagine the other side is going to argue that really we are not talking about a situation where there was an election that was not credible, that we had a sham, a travesty. Can the reasonable Kenyan go to that extent and proclaim that we did not have a credible election, howsoever? If you look at the entire process,
yeah,
I doubt many Kenyans would make that verdict.
So based on your argument, Prof, how much will public interest play a role in the judgment of the Supreme Court judges?
It matters a lot, because look at it this way. The whole point of having these elections, and if you look at our constitution, it is geared towards ensuring that it is the will of the people that counts, not the will of a minority, and certainly not the will of some judges. And that puts judges in a very awkward situation, especially in a very contested election like this, because there is no decision that they're going to make that some quarters will not disagree with. And so they have to be very, very careful not to be seen to be overturning the will of the people or expressing something other than the will of the people. Either way you look at it, if it decides for Azimio, some people will accuse the court of favoring Kenya Kwanza and vice versa. And that is why the courts have to be very, very careful. And that is why the substantial violation test is a very subjective one. Because from Raila Odinga 2017, and this is my criticism of the decision, a substantial violation is what the court sees or believes or deems it is. It depends on the perception of the court. In 2017, five of the judges perceived it that way. Two of them were very vehement that it was not. And sometimes I think it's good to give room for doubt. Could it be that the two minority judges had a point when they are saying that, look, let us not imagine that elections are perfect, because taken to its logical conclusion, the 2017 decision is that the court will not tolerate any violation of the law or the constitution. But that's a very high threshold, because there'll always be instances where you have issues with each and every election will have issues. And so you have to ask yourself, are we going to nullify each and every election because of irregularities?
Yeah.
Where will we be able to draw the line? And will we be able to carry the public along as a court? And that is why my argument is that a court really has to take a big picture approach to the election in terms of deeming that there was or there was no substantial violation. If you look at the big picture, yes, an election is a process, but you look at the election in its entirety, not discrete parts of it.
Yeah.
The quarrel that many people have with the 2017 decision is that it looked at the election from the perspective of discrete parts of it, the transmission of results. It did not say that, look, voting and counting were not done properly. So similar scenarios are likely to play here, and the public will be observing and saying, look, Is this really a case where we feel that the outcome did not reflect our will, and therefore the court will be justified?
Yeah.
The court will have some legitimacy in making that determination for us.
Yeah. But Prof, this public interest we're talking about is
Yes.
a very thin line, because whose interest or which public are you talking about? Because you see, the numbers here were very close. Based
Yes.
on IBC numbers 7.1, 6.9.
Yes.
So when you talk of public interest,
Yes.
which public exactly?
Which is why I'm saying it's a near impossible task.
Yeah.
Because the decision of the court has to appease both parties. The ones that lose must see that it is credible, that the decision of the court is credible, just as much as the ones that win. And so it puts the court in a very, very difficult position. Choppy waters, I call it. Very, very choppy waters.
All right, let's see what you're saying online. Let's bring that up and see. I see there's Bob Otieno Owino. Says IBC Kenya conducted this year's elections according to former Chief Justice Maraga's ruling. It is going to be a tall order for the Azimio la Umoja One Kenya to overturn Kenya Kwanza's win. Okay. Kinyo Mushoki says original Form 34As, the final results, were verified and received at Bomas. A recount case will involve opening the ballot boxes, but agents appended their signatures on the Form 34As without coercion. A recount is not possible. Okay. They say Kukugredi says a server is not PDF forms in a public portal. It's also back-end program handling upload and download. Someone with credentials can still log on to the server and replace those forms. You need an audit of the server and KIMS to know who did what. Okay. Kipto Ruto says the IBC commissioners have the work to tally and verify the election results. It is not their business to discuss on the final results. Chebukati is the only man mandated by the Constitution to declare the winner. Okay. Anthony Khan says, in my view, it seems like the other commissioners' duty, save for the IBC chair, ended at announcing their constituency results of the presidential votes. They were not involved in the processing, tallying, and determination of the winner. Isaac Mudusi says, let us hope the 4 IBC commissioners won't be Raila's eyewitnesses in Supreme Court, and if they will, why? Is that even a possibility, Prof, when it comes to the dissenting commissioners? Can they play that role?
No, I don't think they're playing a role as witnesses for Azimio or Raila as such. Huh? They were part of the process. I think they'll be saying that this is what we observed.
Yeah.
Yes.
All right. Echesa, there's a direct question here from Uncle Fred Bachi Machoka. He says, ask those learned people if there are specific clauses in law which make it extremely painful for an IEBC official to deliberately bungle the electoral process. Echesa.
I think that speaks to one of the prayers that Azimio is making, the one that is directed at punishing the chair in his individual capacity as the chairperson of IEBC. Largely, it is the commission that is held responsible for a bungled election. But what Azimio is asking the court to move a notch higher, having declared that an election has been bungled, to proceed and punish the person within the commission who is responsible for the bungling of such an election, which is a very good thing. And the Supreme Court now has a chance to develop jurisprudence on how election courts are going to deal with IEBC officials, commissioners, returning officers, and staff who deliberately bungle elections for whatever reasons. As Fred Machoka says, we may not be having very harsh and punitive laws to cure this mess by the individual commissioners and individual staff of IEBC. But if that prayer or the prayers are sought by Azimio are granted and the elections of 2022 are found to have been bungled, and individual commissioners or the chair of IEBC or staff of the IEBC are brought to book, I think going forward, these election officials are going to deal with the elections in more progressive manner than they have done before.
Yeah, Prof, and if the backs of IEBC, is there a need to hold criminal capability to be individualistic, as in you're personally held liable for this process?
I think so. That will be a good deterrent to future officials, that you need to take your oath of office seriously.
Yeah.
Because in the past, in fact, in 2017, the Supreme Court nullified the election, but it stopped short of holding any IEBC officials culpable. And that, I think, left a gap. Because it's all about accountability. If there are no sanctions, if there's no fear that I could go to jail if I did certain things that I'm not supposed to do, then what will deter people from bungling elections? So that makes sense. But the other interesting thing relates to the role of the chair and the commission. And I've listened to a lot of talk, particularly on TV. Some people say it is the commissioner's role. Some people say, well, but the commission is an entity, it should act together. My sense is, number one, we have a problem in terms of how Article 138 was drafted. Because if you look at 138 3C, it says the IEBC, that is a commission in its totality, shall tally and verify the count and declare the result of the election. And then you go to 138.10, where it says the chairperson shall declare the result of the election. So both of them seem, it's clearly have been given the responsibility of declaring the result of the election.
Yeah.
The question is, how do you resolve that? And I think it will be a matter of interpretation by the court, but I think that the court is likely to take a sensible approach to this and say, what is it that we intended as Kenyans when we made this constitution and when we gave these provisions on relating to the procedures in a presidential election? Did we intend that the chair can act unilaterally? Did we intend that the commission should act democratically as an entity? What if that is not impossible? What if that is not possible in certain circumstances?
Yeah.
Are there situations in which the chairperson would be justified in acting unilaterally? But it's a matter of evidence. I think there is speculation as to what happened. We really don't know. But I would imagine that we want a clarification of the law, because I think these provisions, from reading them as a lawyer, I don't think they were drafted very well.
Yeah, because that then brings in another issue, the unanimity of the opinion. How does that then affect the will of the people? So if the people wanted to choose so and so, and the commissioners dissent, and then the majority's will are taken, what if their will is contrary to the will of the people?
Precisely. I would imagine that you're talking about the commission, the commissioners acting together, saying, have we ticked all of our boxes? Yeah. Before we announce, before the chairperson goes ahead and announces the results, have we ticked all the boxes? Have we tallied everything? So you see, for example, Azimio is claiming that as at the time that Chebukati was announcing the result, there were some 27 outstanding constituencies. So was that premature? I think that is what is envisaged. Let us make sure that everything is ticked. We have ticked all the boxes, and then finally we can announce.
Okay.
With the blessing of the entire commission. But that won't always be possible, human nature being what it is.
Okay.
There won't always be agreement in the commission. So how do we resolve that moving forward?
Echesa, closing remarks, very briefly.
Closing remarks is that, in my opinion, the Constitution talks about the commission, and the commission involves or includes all commissioners. And the commission is not just a conveyor belt of taking Form 34As as captured in Form 34B and placing in Form 34C. It requires verification in an open, transparent, and fair manner. And that is precisely the question that Azimio has put before the Supreme Court. It will be interesting to see how it goes. And remember, it is the Maraga's decision of 2017 that has held this country together, even in 2022. If the court had not risen to the occasion and nullified the bungled election in 2017, Kenyans would have chosen the streets over the courts. But because they have the faith in the court, the apex court, they have chosen to be cool, to be calm, and wait for the outcome. We believe that the Supreme Court will assess the evidence as adduced and make a just and fair decision.
Okay. Prof?
I'm looking forward to the Supreme Court petition hearing, and I'm hoping that the Supreme Court will come up with a verdict that helps the country move forward. In many ways, of course, you can criticize the 2017 decision of the Supreme Court, but it has helped to advance the electoral process. I think this election, so far we can say that there are aspects of it that were done very well, thanks to the 2017 Supreme Court decision. So hopefully the next decision will similarly advance the cause of electoral justice, and above all, keep the country together.
All right. Thank you for making time this evening, Professor Kech Migai, Advocate of the High Court, and Kennedy Echesa, Advocate of the High Court as well. It's a battle of the legal minds. We'll see what turns out. The 5th of September is the final day. A lot of things are going to happen in between here. That's why we leave it for now. My name is Trevor Ombija, and thank you for tuning in to Kenya's Choice right here on Citizen TV. Stay with us. Bye for now.
Thank you, Trevor.
Thank you.